program, we will talk about law making process. We get inside the program today for talk about this topic. Ibrahim Tawa Conte, we na the Deputy Speaker of Parliament, and Paul Kamara, we na private legal practitioner and also na lecturer na the University of Makeni. Go can talk on this topic we deal with today. We na the law making process, and Fambule una self go get the opportunity. Usai una go text to the number 077 981 981 077 981 077 077 981 981. So you self go get the opportunity for text and ask question, and also even call na the program. With time we go get for open with full line. We say people and go call and ask questions. The Master Sabi people and dinner we go answer on a question, and the question go be related to waiting with the discuss now, not to anything out of this topic, but now the topic where we deal with today. Now in people and for ask question and make their own contribution. Well, inside the program, as I've been telling you earlier, for now we get Paul Kamara, what you say, what talk say na private practitioner and a lecturer at the University of Makeni, a constitutional law lecturer, where you can talk about the law making process. Paul, good afternoon and welcome to the program.
Good afternoon to my learned friend, and also good afternoon, listeners. I hope say we all go get a very good time together here inside the studios.
Okay, yes, and before I go for material, and I would like to ask you, Mr. Kamara, people don't they talk about law making process. So what's the law making process?
Basically, the law making process, now the respective procedures where the law don't prescribe with respect to how a particular bill they come into effect and eventually become law in the country. And so by virtue of the provisions of the Sierra Leone Constitution Act number 6 of 1991, in providing section 105 say Parliament na get right for make laws in Sierra Leone. However, by virtue of section 170 sub 1, it provide for sources of laws. And so one part of the ways them also really make laws in Sierra Leone are through delegated legislation, where from that provision where quote na section 170, any other body where they in Sierra Leone, for example, their administrative tribunals, their institutions, universities, schools, then get right for make laws them where they regulate the conduct of their own respective subordinates them. And so the law making process now how the law did they make them until it come into effect, and then it begin the old people eventually it becomes binding, because at the end the law can say when the law don't come into effect it becomes binding. And so this are the law now that the law mean way they say law making process, how the law they come into effect.
Okay, so we don't you quote one provision just the Constitution we give various sources of law, so we can go into the quick one.
Yes, by virtue of section 170, we provide for the sources of laws in this country. It clearly becomes obvious to Sierra Leoneans, academics and non-academics, say the number one law by virtue of that provision, now the Constitution of Sierra Leone, where simply means say the Constitution are the ground norm, the law from which all other laws they get the efficacy. And in law, when they say law becomes efficacious, now the process by which the law will bet person and the law will get strong backing we normally by virtue of section 40, as in sub 3, the president, na the guardian of the constitution, really helpful na constitution, the whole water. And the second law, na laws them we parliament make, we normally then can call statute. And then statute here so, different ideas in way either from an individual, from what they can call private bill, or from government officials or MDs, then pass on through the office of the Attorney General and Minister of Justice, and then in draft time all that kind of thing and follow the appropriate procedures, and then it come into force. And the other type of law where they in Sierra Leone, then call them either others rules them where somebody where Parliament confer the right for make then laws in the way normally can call delegated legislation in law. And the other one then call them the existing laws. The existing laws, these are laws and way be don't in force before the constitution they come into existence. Let me not forget say this constitution is gonna come into effect in 1991, just after we then be repeal and amend the 1978 one-party constitution, and so soon thereafter we'll be able to get the 1991 constitution. And this 1991 constitution will be get by virtue of that provision they simply give the impression say when it comes to the laws them, the existing laws and they also don't form part of Sierra Leone. And there is one provision of the law we then call the receptive clause. That one in section 74 of the Court Act, where say all the laws that will be done in England will be done in force in England before 1st January 1880. They all get effect in Sierra Leone. And so then one any are the existing laws. And that makes Sierra Leone up to now they use laws like the Perjury Act of 1911, where they use the 1861 offenses against the Persons Act. All the law they will still use in Sierra Leone. And the other type of law we form part of the sources and we call them the common law. And the common law basically you and I know say when it comes to the historical perspective of law, we trace them back to England after the Norman conquest of 1066, where then they conquer states them, and any state to then conquer, automatically the law will be the happen at the general English community, they get effect there. But because of the progressive nature of law, equity come into play. But there are still laws in Sierra Leone. For example, murder, there is no law we provide for murder. Until recently we get the repeal of the death penalty, where we get now a particular legislation where they speak to that. However, then already they prefer charges them, they say contrary to law, murder contrary to law, manslaughter contrary to law. That means say these are common law offenses a way still get effect on Sierra Leone. And these are the different types of laws and we Sierra Leone get by virtue of pursuant to section 170 subsection 1 of the Constitution of Sierra Leone.
Okay, so we get the receptive clause.
Yes.
Where you just talk about. So let's say before that is 1880, before that time.
Yes.
So now any law we get now is still applicable to that receptive clause?
Well, normally what in a receptive clause simply means only laws will be the England before that period they all get effect in Sierra Leone. That make we use archaic or draconic laws. So when they say then tete laws them we don't in England for the longest of time, we still rely upon them here. So for example, the Wills Act, the Wills Act na 1837. This na law will still get effect in Sierra Leone. And not only the Parliament of Sierra Leone be legislate na law, the law will be inherit. And that one day, now by virtue of this section 170 subsection 1, specifically paragraph D of the Constitution will provide say existing laws. Then laws that will be known they exist before this Constitution come into effect. The laws they will still get water, we still the old water in Sierra Leone, and we can rely upon them for take whatsoever action we want to take, and for also help for regulate the citizenry in the best interest of the spirit and latter of the general principles or provisions of the 1991 Constitution. Make me not forget say section 171 subsection 15 of that Constitution they talk about the inconsistent nature of laws. Any law way be inconsistent shall, to the extent of that inconsistency, be considered to be null and void. And so the existing laws therefore bode well towards the promotion of the principles same way they inside the 1991 Constitution. Now that make, if you see right now, we don't repeal the Fange Act. The Fange Act. Fange Act now laws away alone in 8. And one part of laws also, because no not be the bode well towards towards the existing nature of how we laws and on the day, and not be the bode well for promote the current democratic principles of Sierra Leone. They don't repeal and amend them.
Okay.
Yes.
Okay, so Paul, you don't talk about the law then day. So how is it common now for good parliament?
Well, basically, like I be the suggest where we start off. Parliament's not the lawmaking body by virtue of Section 105. It provides, say, there shall be a parliament which shall be vested with the supreme legislative authority. And if you proceed to Section 106, it provides for the legislative process, the lawmaking process, where normally it can be in the form of a bill, and a bill like a proposed law. So the first stage, when I'm in the unofficial stage, and call it the drafting process. The drafting process, this is now a process wherein either a ministry of government or agency, they come together and say, "Law address a particular issue." Then pass on to the office of the Attorney General and Minister of Justice. Then get the drafting committee there. Then draft them, present them to Parliament, and we got something called private bill. When a member of the public, anybody can come up. If you see, say there is an issue where it demands with urgent attention, if you come up with an idea and then you work on them, you present them to Parliament. But there is a procedure to that. And the other stage, they call it the first reading. You know, every document we then keep present to Parliament, you get different parts. For example, a bill, and you get the short title and get the long title. But this first stage, they can normally read the long title of the bill to Parliament. They not debate on them, they not talk anything on them. They just say, officially present them to Parliament, say there is such a bill, we don't come to Parliament. And from there, they get the second reading. This second reading now they can present the general principles and policy, then way basically they guide in a particular bill. Within a bill they all about. And these are the most critical parts of the debates.
Okay, so my holiday, and we get we just be joined by the Deputy Speaker of Parliament, we na Honorable Zawa Conte, we na part of this program. Deputy Speaker, you don't hear Paul, the lecturer na University of McKinney, we also na a lawyer, and don't talk about the second reading. You did a Parliament, so take we through the second reading.
Well, thank you very much. I think it's also good that we get Paul for maybe do a simplified civic writing on the processes of lawmaking and things that we will be able to enrich the knowledge of picking them from a early stage. Because if you look through the American system, you will see every American know how the amendment and they from the first to the 20th or whatever amendment, they know how then they and they know what they stand for. And most of we don't get access to the law and how the law they operate until somehow we dark in the walls of Parliament. Yeah, and if you not get opportunity for go Parliament, there are people who don't go Parliament, who don't go through Parliament, where the lawmaking process is still difficult for them. So the second reading, like you say, the first reading, like we just give the minister the opportunity for like come and present the long title of the bill. That the bill entitled so and so and so and so and so, so we make provision so and so and so be read the first time. And when you don't do that one day, the speaker they put the question to the members. For accede, say yes, they don't agree, say let them read this bill the first time. Then in a voice collection. If a bill where you want for like way they say for count to the second reading, pursuant to SO 49 or 48, what you they do now for you allow the minister for read the memorandum and object of the bill. Because when the bill they come in SO 47, after all the publication, after all the 9 days gazetting, where you get for do, because every bill, like Paul say, you get for draft and force. Mostly the policy drafting, they start from the ministry, the initiating ministry, the ministry will work out this bill. Say na a bill get for do with national emergency, for example. Who that responsible for national emergency? Say something the NDMA, National Disaster Management Agency. But because National Disaster Management Agency, not to a ministry on their own, they under the supervision of a particular ministry. So they draft a policy from that stage, from the department stage. Then they escalate to the minister. But when we reach to the minister, there is something where the standing order SO 18 require from parliament. Say every law they can parliament in the form of a bill, you therefore don't go through consultation. So the consultation now they do what they enrich the content of the policy. So if you get this idea, broad idea, not of only work for Mange, not of only work for Tawa, not of only work for Samola, for work for the people of Sierra Leone. So you get for go district by district where necessary. You get for go maybe chiefdom by chiefdom, bring in chiefs, bring in stakeholders. Where now then stakeholder then they interface with the law. And then get for do the implementation of the law. So you get a view. Say, okay, the fine way they per the 1919 act, last in the act or whatever. That fine the one for law review. What how now one for this car fine for be? Law move on from 5 leons or from 1 leon to 1,000 leons. If you cannot by yourself Mange, you say okay, they put 20 leons there. We can pass on the parliament. The people like say, oh, first thing they ask for where is the consultation document? Yeah. Because it is expected that the minister should bring the consultation, the outcome of the consultation, what they do. We should say yes, they agree to then clauses there. So after the policy don't develop, you don't go through consultation, then they can send it to the Attorney General's office. Like Paul say, that they go draft the law, now you get a draft man, and that is the problem with Sierra Leone now. I can tell you, and it is something the legal profession has to invest in. We get only one draft man. One video will be the young man video with the Pato Mr. Thompson. We only get one draftsman, the law officers department. So Parliament by itself supposed to get a draftsman on its own. Because the purpose of the 1991 Constitution, like we Paul say, now that it envisage not only bills coming from the executive, because if you go to section 93(5), it say the oversight responsibility of Parliament for inform the passage of legislation. So if you do oversight now on environment, you realize say there are gaps. Okay, like you real scenario in the PAC. When they do the PAC hearing, I realize now say for women to take over a PAC, I realize say a major challenge in the voluminous nature of the audit report and the fact say there is no penalty if somebody use the wrong procurement method. So in the Public Procurement Act of 2016, it state the procurement categories the way for do. But punishment not really say if you for use competitive bidding, if you use request for quotation, what not the punishment in order. So the oversight function of Parliament, like what they do down so, is supposed for inform a legislation. Now, if we want to review that legislation, we will consult with NPPA, we will consult with the Ministry of Finance. Then we forget to own draftsman who they draft the purport of the clause 01 for review, or 01 for repeal, or 01 for amend, because the law gets two parts. You either amend or you repeal completely. When you amend, now where you say okay, provision and there so where I want for keep, but I want change the wording. Say it say for violation of this particular offense, the offender shall pay 1,000. Now if you want for change 1,000 to 5,000, you would amend. If you want for repeal and completely, you want for bring come new provision in instead, then you dey repeal. So it's either amend or repeal. So if you not get draftsman at Parliament, it's a problem. So the second reading now, it explain the object of the bill. It take you clause by clause, chapter by chapter, until it explain all now and then.
So what are the importance of the second reading?
The importance of the second reading now it give clarity, openness to the members of parliament now for understand. For example, if you don't read the bill, the second reading is like a summary of the bill. It's like you summarizing the bill in 2 pages or in 3 pages, explaining that chapter 1 contains section 1 to 15, and in section 1 to 15 now this now the main things that you bring come. So you dey enrich the MP, you dey give like directives as to what thing you go look for when it come to the committee stage or when it comes to the debate, because immediately after the second reading the speaker they put the question back, and when put the question, you know they take voice collection again, the debate they start. So it's either way, you can defer the debates in SO 49. You dey get an appointed date for the debate of the bill. It cannot be immediate. You can count until today, then do the second reading. Then maybe because members don't go through the bill properly, you can set a date for the debate. So already members don't get directive, they don't get some perspective on what's in the bill they about. So you know, say I go look chapter 1, you get 5 sections. Then 5 sections here, the critical one then are there. For example, where you carry they couldn't carry the instruments going for the amendment. You see, say everybody was forced about the pre-legislative hearing, because whilst SO 18 they say before do consultation, SO 47 they say the process for the bill come parliament for don't publish in a gazette for not 9 days for the last between the first publication and second publication. The way you counter now, you do pre-legislative hearing. So the pre-legislative hearing is a forum where the pioneer of the bill they get chance for states different like what that to the general will explain study outside them pull this one, what in the idea behind this one, what inform this particular drafting and all. It don't give all man a broader picture. So the second reading, if there's a pre-legislative hearing, most times after the pre-legislative hearing, if you take the bill in the plenary, you can almost one pass on the same day. That is why some bills they come, particularly smaller bills, they pass on the same day. Because if you don't do pre-legislative hearing, then the members don't go read them. Well, after the second reading, they take the debate. And after the debate, then you get the minister in response. So the second reading, in the second reading, and then they get the debate, and then the minister they respond to the things that will come up in the debate. Then after that one day, they commit the bill to the committee of the whole house. That's ending now. They say they go now clause by clause.
Yeah. So, Deputy Speaker, with the senior say, they say the minister will carry the bill, he can participate, but he not a vote. Than our 107. So waiting Andy, how that can happen? Like he go participate, but he no go take part na the voting exercise.
Because like where Paul say, section 105, if you look section 73, now he give birth to parliament.
Yes.
Say parliament, there shall be a parliament of the Republic of Sierra Leone, which consists of the president, the speaker, and members of parliament. Then if you look 73.2, it tells you what in parliament they do. They say they make law for the peace, whatever for Sierra Leone. So you know they read 103, 105 in isolation of 73. They read them concurrently. So because of 73 they establish a parliament. 105 say that parliament they 73 they establish, and then are the supreme lawmaking body in Sierra Leone. So the members the whole day we qualify through the people and voice for go sit down there. And you no more get chance now for make the law, because now the responsibility. You don't count a proposal to them. The below the council parliament are a proposal. So whatever the outcome, the final outcome when they go to the president, it is now left for the members of parliament and now for do that process way 105 say. So 107, what you make 107 say the minister they participate but in the vote, because we all let debate not take place in the second reading. Somebody get for give response now the pioneer of the bill or the minister. So it go give response. Now make in the process things then they in as much as you need the votes, some recommendations they already come, you they get them back to the minister during the committee stage. For let the minister say, okay, this one a fine proposal, they go to do the finance bill. They go just don't do the finance bill. The finance say it come and knock out with the single window. But we do drafting, we draft provisions where they cover that one day. The provisions were read and the provisions were accepted by the minister and they form part of the bill.
Okay, so thank you very, very much, Deputy Speaker. But Paul will be left one side where will not be clarified. From there we will come to the third reading and we ask other questions. We talk about customs and tradition. Okay. We is a part of the lawmaking exercise. We say na law.
Okay. So basically, if you look at section 170, it provides for the sources of laws, and then sources of laws, and we don't categorize them further to general principles of law and customary law. So then two types here soon, and that make people in refer to Sierra Leone laws as dualist in nature or dualistic in nature. This principle of dualism, say Sierra Leone, we get the English common law or the general principles of law, and then customary law. Now that make we get certain laws then way applicable to Freetown, where you go upline, or the provinces is not applicable, because Sierra Leone come from a historical perspective, where most of the things we get right now relics from the British leadership or governance we get back then. From when they became, they established the colony, then the interland no be there. There was a time they extended to the interland, where then we call the declaration of the protectorate, and we get the protectorate, those extension of the protectorate. Now, for example, if you go upline or to the provinces, by virtue of the High Court rules, you get rights for take any issue where concerns title to land, you use writ, you go to High Court. But at the provinces, you don't go to High Court for title to land. We say they go section 15, sub 1 and sub 3 of the Local Court Act provides, say, you for go through the local court by virtue of that Local Court Act of 2011. So there are laws where applicable in Freetown here, we not applicable yonder, simply because yonder they get the thinking, say most of the practices are governed by customary law, and those customary practices must be maintained and must be respected to the latter, because alone are a country where we believe in tradition. Even with respect to the administration of the estate of a deceased, there are procedures here in Freetown where if you want, you go take probate, you go na the High Court here, so if the person die intestate, you go, you take letters of administration. If the person die, you left a will, when a valid will, you execute them, you go to the High Court. But in the provinces, if you want to take letters of administration, no High Court no get rights for give you letters of administration. We say for go at the local court. At the local court, will authorize you for obtain letters of administration when it comes to administration of estate of the deceased in the provinces. So the issue of customary law, it also forms a very crucial part of the laws of Sierra Leone. I mean, they say customs and traditions. They're all the part of the laws of Sierra Leone.
So Paul, why we get local courts in the provinces? We don't get them at the Western area.
So Parliament, by virtue of Section 105, as the body where in charge for make laws, in their wisdom, see say there was a need for we get into consideration how they dispense justice in the provinces. And so in 2011, they introduced the Local Court Act of 2011, where repeal the Local Court Act of 1963 and 1964 respectively. They repeal on one day. So hence in coming to force, all issues that concern by virtue of Section 15, it talk for say empower them for deal with civil and criminal matters. And the number one court, when it comes, I don't get two types of court. We get the inferior court of judicature, then we get the superior court of judicature, two types of court. Where you go to the provinces and get local court. From local court, you get the district appeals court. If the local court take a decision, you're not okay with it, you go to the district appeals court. Then two courts in all the Freetown here. And from the district appeals court, if also you want to explore any line of action, you go to the magistrate court, we then court in the Tonga. But by virtue of the superior court of judicature, we then at the constitution of Sierra Leone, you get the High Court. From the High Court, Court of Appeals, you go to the Supreme Court, the final Court of Appellate jurisdiction, the most important court in Sierra Leone. So to the question we ask concerning why they get local court, I feel like Nami understanding also say the local court don't they part of the court structure in Sierra Leone. That making it talk about the court structure of Sierra Leone without making reference to the Local Court Act of 2011. Remember when we talk about 170, we talk about under the third limb when it comes to the types of laws in Sierra Leone, we talk about statutes when are laws that were made by Parliament. And this local court act na a creature of parliament. A parliament making a local court act day of 2011. So they contemplate say there was a need for let them get local court. And under the composition of that local court by virtue of section 3 of the local court act, it provides that there shall be a court chairman. So they all serve there as a presiding judge or magistrate or whatsoever. They call them chairman together with members them. Enough for get less than 5 members them. So he did it together with members, and these are members them and people away knowledgeable about the custom and practices of a particular chiefdom. Remember, the local court they only they cover a chiefdom. So, for example, Bombali gets up to 12 chiefdoms. So each of them chiefdom, it is presumed by law say that each forget one local court, and so like Bombali forget like 12 local court by virtue of that provision. So any issue where they arise from now local limits then get it right. However, for criminal matters, not for jail you for more than 6 months. For civil matter, the money not for exceed 50 loans when it comes to fines. So then get limited jurisdiction when it comes to hearing and determine the hearing and determination of civil and criminal matters. Okay, but local courts are part of the laws.
So they can focus on Parliament purely how they need to do their law. Okay. But more we might just ask you this one, though we try for end up. So what about they say me who a lawyer now that local courts they are not get audience day? Like, is that true?
Yes, by virtue of section 19 of the Local Court Act of 2011, it clearly provides say lawyer no get right of audience na the local court. This is simply because these are people who don't understand the law. Waiting they understand na fact, and the fact only limited to customary practices. When it comes to serious legal issues, they don't get understanding. Even with title to land, now that made a limit unto them. They go say, would that first get this property? You don't adverse possession of the worker in the provinces. Free to adverse possession of the worker if somebody don't occupy a place for more than 12, 13 years, 14 years. If you know at any, because some man very careless, you will get portion of land, you just left for abandon them. If somebody occupy them, you don't interrupt them. Don't tell them 2-3 years, you can't tell them property this 2-3 years, you can't tell them. You left for no more uninterruptedly 12 years period. The law they presume so and get the land. So that one they not applicable.
So Alex, if you get paper them lands every
yes.
conveyance.
Yes. For the fact say there is an evidence where they show say you don't ever come to the attention of, especially if you not put now warning when you can normally put na the land. Is a property of Mange. Beware, trespassers will be prosecuted. Now one day, in obvious, they assume saying a constructive notice you don't give them. But in the event where now one they know that they baking so know that they just abandon the land, say this is your land, and that is very risky in law.
Okay, so the other aspect to the way we did done now before we can deal with Parliament exclusively, and we get equity. So we instead of part of laws them. So
yes.
Yes. So
I want to relate to the issues that they talk about. Equity, basically, if you look at section 170, capture all that, both common law and equity. You know, equitable principles, these are principles and we're born out of the desire for treat issues based on fairness. And the principles of equity emanate from the creation of the Chancery Court, when they call the chancellors as the keepers of the king's conscience. So that one, they're purely discretionary. There are times the judge or the magistrate can be left with matter can they in a situation where not only get any option but for using discretion for dispense justice. For example, if I can't tell you say I don't deal with this property, I get all me did same for showing me property this and that I get this document, I get this signpost to I put on the land. Even if I not be can't tell you say na me property, equity go tell you say based on fairness. That is a reasonable notice for notify anybody where go for corner property say this property belongs to somebody else other than you very self. So that one is equity, and the laws are very clear on that. I think it's section 170 sub 3 we provide for now one day we say equity also the part of the laws of silo. Like I tell you, the laws are broadly categorized into two general principles of law, and one part of the general principles of law na equity and common law. You know, these are like two sides of the same coin. You know, when you talk about common law, most of the time you also think about equity, because common law and equity, where equity can remedy most of the challenges or the defects where common law come with. And if you file a common law, at times these are very rigid law to some extent, and so you don't talk about common law. If you want to talk about fairness, you don't talk about equity. So these are all form part and parcel of the laws of Sierra Leone, pursuant to Section 170.
Okay, so we don't deal with the other aspect of the law. So now we can to Honorable Way, the Deputy Speaker, we will talk about probably the third reading of part of the lawmaking process. So how did it happen, Deputy Speaker?
Well, most of the process where the lawmaking path the follow is done mainly in the second reading. After the minister don't read the general principles, the merits and all, the debate is taken. Then when the debate is taken, then the minister responds, then you go into the committee stage. At the committee stage, everybody, the clerks at the table will take off their wigs. Mr. Speaker, they take off a wig, but Mr. Speaker never wig, Mr. Wig. So at that point, Mr. Speaker becomes Mr. Chairman. Then the clerk at the table, they announce the bill as initially read by the minister in the second reading, clause by clause. So now it will say chapter or section this, clause 1 to 15 form part of the bill. They will begin to take page by page now. So as they go page by page, any member now will get any issue with any line, any phrase, any clause in the bill, because the bill where they come, it is not section until it is styled bill under 106 and signed by the president, and it becomes section. It comes at clauses. So clause 1 to this. So when we don't go through all the clauses then they with amendments.
Then I don't in the second reading.
The second reading is continuing. The only time the second reading they done, now after I don't take all the clauses I make, what in the bill they do, now that if you bulk, you know they take all together, you take clause by clause, so you divide them from clause 1 to 15, or from clause 1 to 30, chapter this to this form part of the bill. The chairman gonna be the speaker. They go now page 1, page 2. So all man go don't go read now during that debate, don't take correction. At the time that they begin to take correction, they start from the first page, long title. If you okay with long title, say long title is approved. That is if it's a bill where parliament not commit. Because that is another phase one if I explain to you. A bill they come after the first reading, and sometimes after second reading under SO 51 they commit them to legislative committee. So legislative committee they go together with the minister, for example the GIWI Act or the criminal libel repeal, the death penalty, the IMC, a number of laws they all don't pass, where they go na legislative committee, where they commit to the committee stage. So the committee, they go to committee and SO 51. I wouldn't commit them. Legislative they go work now with not only the ministry or the pioneer of the bill, but the minister in team. Then are they now they take consultation there? Are they now they take consultation? They take position papers. And then position papers they can say all man they get view. So all of that one then they form the committee reports from the legislative. So if it's a bill, whether at the second reading, after I don't take the debate in the second reading, then you commit under SO 51, where it come out from the committee, from the legislative committee, where they read the report. You don't take a debate again from the house, but it is also going to be a debate continuing, because at that point now the legislative committee they present a report and a recommendation from the bill that this clause be expunged, that this clause change to this, or if you expunge this clause then this number don't become this number. It moves like that. So once they presented their report, then they go now to clause by clause. So the clerk will announce the clause, then clause 1 to 15, then Mr. Chairman they go now page by page. So members them, the reports together with the original bill will become now they inform the passage now of the law, the process now one by one, page by page, till you don't the entirety of them. And we don't do that one day, all them banter, the arguments, the discussion, the challenge, it gets to some point. There are certain clauses during the second reading, after the presentation of the legislative committee report, if it's a bill that is committed to the legislative. If it's a bill of the whole house, there are clauses they will go by the bill, who go disagree, you never get vote. You take vote for him. Say this one, say this one, this one, say this one. That is where we need the draftman. Because at that point, most of the changes to what they happen, if now you the preside, me the preside, I notice the legislative chairman they note down. Because when the bill done, when they can go to government printer, between me or Mr. Speaker, if not Mr. Speaker they preside, or me preside the bill, I get for go now, wake up, I get for go back line by line, page by page, and look at all the changes that what the parliament, what the members of parliament don't vote for, say it reflects in the bill. So after all that one they done, in the second reading, they don't make all them changes then the first clauses they would announce. The minister, they announce, they put the question on, they put it to the house now, say clause 1, chapter 1, section 1 to 15, clause 1 to 35 form part of the bill as amended. Then Mr. Chairman, they put the question now after I don't announce that day. Honorable members, the question is section 1 to 15, clauses 1 to 30 form part of the bill as amended. All in favor say aye, they say aye. They will go to the next set of chapters and clauses until you done them. So they do them face by face. When you don't done them, under SO 53(7), if you get anything now you want add any new clause where the bill not carry it, then you can propose her. You make your proposal now. Then that proposal is members of the debate them. If you get consensus whether it is good for be added to the bill or not. If it is not good, then they will just expunge her immediately.
So meaning not to waiting the minister no more would put. Not to no more. So if you not get anything for add,
that is where your constituency's interest come in. That is where oversight engagements come in. Because at the end of the day, if you want to talk about something where they talk about prevention or environmental degradation, and you get to do with stone crushing. I know say my own constituency in Alumni, most of their livelihood are for Brookstone. Yeah. So then go don't tell me something where they're not there against for what they call it, for put law for Brookstone, but maybe the fee we go apply for that one day in order the law, or sometimes a particular provision will go be a safeguard for them in order the law. So if the proposal safeguard for be added to the law, and if the members they agree, that safeguard will be included into the law, and then una can draft and out together with the draftman for let be proper drafting, let be in a legislative drafting format. So once that is done in the second reading, then the minister will come back. The last clause on the deal with, he announce to the members that section 20 clause 15 to 35 form part of the bill as amended. Chairman will put the question. The question will be carried, and after the question is carried, then the house resume. Because the whole house, it's a committee of the whole house doing the second reading after the debate, when you don't take a clause by clause. After I don't go through all that process there, then the parliament says now decide the power only for make law. The mace they open and back, and clerks then put on their wigs. Mr. Speaker, if you get a wig, you put on a wig. Then the minister they report now to the house that the bill entitled so and so, having gone through the committee of the whole house, I therefore move that the bill be read the third time and passed into law.
So meaning after the second reading, it get the likelihood for becoming law.
But once you don't go through the second reading, don't do all the amendments, you don't make all the changes, the members don't agree for all the clauses them, they don't get no disagreement again, then the mace is uncovered, weeks on, the minister now they report what happened at the committee of the whole house to members of parliament. So when the members of parliament listen what they no reports to them as they non debate, then minister they move now say they have a move that the bill be read the third time and pass into law. Then Mr. Speaker now, because he don't move from chairman, the house don't resume. Mr. Speaker now they put something to the members them that the bill entitled so having gone through the committee of the whole house, the bill be now read the third time and passed into law. Then put the question now, all in favor say aye. And something critical for the passage of bill, you don't need 2 thirds. Now the lowest threshold way you need for the parliament. The only threshold way they closer to passage of bill na quorum. I think that's section 91 and of the constitution where they take 1/3. But anything now where you for pass law, now just 1/3 of members then.
Okay. And before we go to the assent of the president, when we look at constitutional instrument, so if na a constitutional instrument, what's required for me pass?
Okay, a constitutional instrument, you get 2 sets of instrument there. You get statutory instruments in 170, you get constitutional instruments. Statutory instruments now the instruments we born when at the creation at the grand pikin, because the act of parliament now the pikin of the constitution under section 106. The statutory instruments now the constitution in grand pikin, then the act of parliament now in bonam, because the act of parliament they give the minister or the agency power for draft regulations. So the regulation wey they draft, they come in the form of statutory instruments. So what does the statutory instrument do? If I come to the constitutional instrument, the statutory instrument they give further explanation to provisions in the act. For example, if a provision they talk about submission of audit reports in the Public Financial Management Act, for example, yeah, you say the Auditor General shall submit its audit report to this, and queries and responses should be done. So the regulation where they govern that particular act, now they explain now the timeline where the query for be responded to, whether they for respond to the query, whether they are the accountants, whether they are the permanent secretaries. Now the statutory instrument, and they provide further explanation.
So what's it required for me then pass statutory instrument?
Okay, for statutory instruments, what you require now that the minister will bring it. If anybody go, I'm coming. The minister will bring it. He will table it because he need debate. The only way debate statutory instrument now. If somebody, MP, a member of parliament, get an objection, say I move that this instrument be debated. Then at the time you debate that instrument, but the mover of that motion now parent the owners day now for put 2/3 for defeat that instrument day. Similarly, if you look where we they do in the 5th parliament, where we pass the constitutional instrument for the setting up of the commission of inquiry, you realize say when the document was tabled, the Honorable Daniel Koma give a notice of motion, because under SO 25 it say any instrument with the table in parliament, if you get any concern about them, immediately when they table them, you dey raise the concern, you dey give notice of motion. The notice of motion about say I get concerned about this document too. So this document will not out. So because I get concerned, I go want for we debate them. Mr. Speaker will note it. When Mr. Speaker note them, you go realize say under section 170, section 177, it say the instrument, if not debated, it will take 21 days na the table, then they turn law. Then they use it now, the court they use it now. The Supreme Court now under section 124 can use an as interpretation and document for enforce other laws the way person will break. So if they count the instrument, nobody no ask for a debate, nobody no get notice. 21 days they take at the table with all law. If somebody get notice, the minute the person get the notice, counting stops that day. The counting don't stop. So when you don't get a notice there now, you don't go draft your motion. But every motion forget a seconder. If you don't get the seconder, the motion will get leg. So when you get the seconder and you they sign the motion on a deposit at the office of the clerk. When a deposit at the office of the clerk, the committee were responsible for put the order of business under SO 14 and 15. The business of the house, they sit on them and they set a date for the debate, like they do for the constitutional instrument under section 147 for the establishment of the commissions of inquiry. So for the constitutional instrument, now you move the motion. Now you get the owners for count 2/3. So if you don't get 2/3, the only way they do, you go get a public attention, you go get your voice be heard, then go do the debate. But when they put the question, if you not get 2/3, then the bill is then at the table and the counting they continue until it mature and turn into a law.
So what about the constitutional the constitutional instruments? What's in need for me to pass?
The constitutional instrument, like the statutory instruments, all what you need, and don't forget an objection. If you get an objection, they will too go through the same procedure. You get for muster 2/3 for let you defeat the instrument to the count. If you count instrument for census, you count instrument for.
So who are the owners then now to constitutional instrument? First, you say statutory instrument. The one way is the motion.
It's the same. The person will move the motion. Now the owners deal on them for let able pull 2/3. If you go to section 177, it will tell you say the owners they on you now. For let you canvass me, you canvass paramount chief, you canvass other members the under. For let them see the value of what you make you object to this constitutional or statutory instruments.
Okay. So well I'll come back to you, Paul. We don't talk so many. We don't talk, but other side and the way we also need. So we in terms of lawmaking, we can go to the call entrenched clauses and anything. What do they mean, entrenched clauses?
Sorry. Basically, the Constitution of Sierra Leone then drafted in a way that we get general provisions. When I want the like waiting, the deputy speaker they say you can go to parliament. Anybody can look at certain issues. They say we need for amend. Now one day no need for involve the people. Entrenched clauses now clauses where the law they capture in a way that because now laws the way they directly affect the people well-being, they allow nobody or any authority for just decide they're going to parliament to amend them or repeal them. So by virtue of section 108 subsection 3 of the Constitution of Sierra Leone, it provides clearly for entrenched clauses. So many one, and one part in entrenched clauses in chapter 3 of the Constitution of Sierra Leone. Chapter 3 provides for fundamental human rights. So if you want for touch any one part of one day, you get for go through a referendum where they involve the people in just like any national election. So, and now one day ECSL can preside over now one day for ensure say the people in voice and be heard, like waiting honorable be told you in terms of consultation and another form of consultation on one day.
So honorable, we get these amendments now we to go on. We get so entrenched clauses and then entrenched clauses and then get for go for referendum. You get some we not to entrenched clauses then. So if first of all the minority leaders say if they not go through the referendum, it's tantamount to treason. So what do you think?
Well, also section 108, I think now subsection is it 3 or 7? Or is it 118? Okay, section 7. It's 1087. It says no act of parliament shall be deemed to amend or to repeal or in any way alter any of the provisions of this constitution unless it does so expressly. Then 8 now. It says any suspension or alteration or repeal of this constitution other than on the authority of parliament shall be deemed to be an act of treason. So what's in the opposition there they say? Now that even the non-entrenched clauses they did it under section 108 where they talk about alteration of the constitution, it tell you what's in at the stage. First read you do so today. You know, not get no threshold. It's a voice collection. But from the second reading, you forget 2/3. Because the second reading, we don't know, and you can debate the clauses there. You forget 2/3. Now, in the case of entrenched clauses, the law not prevents anybody for count a bill with entrenched and non-entrenched clauses. But you follow the ramification. So if you count entrenched clauses, parliament can look at them, then give them 2/3, but president not able for sign on. You know, they will send the certificate of ratification to president. You get for either remove her from the bill and set her aside, or you commit the entrenched clauses then to a referendum. After the referendum is taken and approved, then you take the entirety of the bill with the entrenched clause to the president for let's sign them as one whole. But in this instance, there are two options available to the pioneer of the bill, the minister, and to parliament. Either you make parliament debate time, you fight for 2/3 and you go for a referendum, which is a very long path to clauses them or sections their way really affect the livelihood of the people. It is 85 and 87. We talk about the lifespan of parliament and the time of election. So you either do that one day or you expunge her immediately. So once you expunge them, it is no longer an issue. So all what's in there now becomes an issue where you only need 2/3. There couldn't be amend section 79 and 80. We're going to do the election of the speaker and deputy speaker in 2013. You not be need for go for referendum because they are non-entrenched clauses. And if you look at the entrenched clauses, there are clauses that were critical to the body politics of Sierra Leone. So no left and loose no more for let us in Kaika amenda. Like where Paul say chapter 3, the entirety of chapter 3 is entrenched because you cannot do policy in life, you cannot do policy in liberty, you cannot do policy in freedom. If you give me chance for that change and ask when we get the number, tomorrow morning they cannot say man gave them for arrest them for this crime. They don't violate this crime. But because the drafters of this constitution envisage and they protect chapter 3 and then further highlight specific sections. Section 56, section 87, section 105, section 110, because these are clauses where like 110 they tell you about taxation, alteration of tax, and nobody no go alter any tax now except by or under an act of parliament. Because if you give one person the power tomorrow morning where they say no tomorrow Paul they pay tax for thing they will bring income or man get no pay or Sambola no pay, but you cannot do that. Now you make audit service creates issue of duty waiver and concession. Audit service they rely on 110 because 110 is entrenched.
Okay, so the as we round up the new the amendment now we go you get someone then the winner they no entrenched, you get the one they with the entrenched. So somebody been they say if they pass the one day with the no entrenched because they all did together, then probably you decide for go for if they all did together, you know, give the precedence for sign up until they then go for referendum for the non-entrenched clauses. And so waiting I want to do in that direction.
If you ask me opinion, my personal opinion, because my opinion I will give on that day. If you ask me personal opinion, I will tell you for the avoidance of controversy, you expunge it. If you ask me personal opinion, for the avoidance of controversy, you expunge it because materially, Paul will tell you, say materially in the law, you know they add no value to the bill. The only value they add to the bill is that because you propose a fixed date for a presidential election under section 42, you want to also fix a fixed date for parliamentary election under section 85. And because you say the calendar will work that way for presidential election on this particular period after the first election, whether they will not take place, you want the parliament's lifespan 1 day. But let me tell you disadvantage. As a member of parliament, see disadvantages for parliament because it means to say the calculation way they use for the executive is different from parliament. You know why? Because after the conduct of the election, parliament does not subscribe the oath immediately. Parliament does not take office. Parliamentarians does not take office immediately. The president, the day when you win the election, the day don't subscribe the oath, the day counting don't start. But parliamentarians now, you gotta go through orientation, you gotta go through some training, you gotta go to ECS language certificate, you gotta work out on a parliament get to that certificate, then gotta publish them, you gotta do all that thing in there. So now 2 months after the election, the members of parliament they constitute. So you need to say if you put the same date you get for the president, you will always deprive members of parliament from the full lifespan of 5 years where parliament supposed to exist for. So there are lacunas in everything where they happen, but you they pick and choose how you handle that.
I think with respect, me gets a short shift to now view this simply because let's say if you take 2 month process or processes them for let parliament taking actual effect, I feel like they pay them for now backlog day.
No, they are not paying them for. And so they begin pay you, Paul. Now the day when you subscribe, they begin pay you. Not after the election.
So like you rightly suggest, I would rather suggest they expunge them, or we follow the spirit and letter of section 108 subsection 3.
Yeah.
Because for the fact that they make mention of them, it means the legislators at that time contemplated this kind of act, and so it cannot, we cannot use the word, the laws to again affect the laws. We have to follow the law to the letter. For me, a positivist, what is the law is what is the law. This is what the law says, and this is what we need to follow as far as the law is concerned.
Okay, thank you very, very much. Paul Kamara, lecturer, University of Makeni, we join with today at this program, and plenty thank you to the Deputy Speaker. We left all in busy schedule, the different things in the Parliament for Canada this program. I tell you plenty thank you. When I think now I will draw the curtains for today's program. Plenty thank you to Fatimata Samura, the one we make it see live on Facebook. Plenty thank you to DJ Caps, the man we did behind the mic. Plenty thank you to Theodore Arena, we he put the script together, and the executive producer Michael Sambola. Me we present the program in name Namange Mansari. Stay tuned. Next Tuesday we get another edition we will bring come where owner self go like. So now I would go the cuttings for today's program. Plenty thank you to now all the listeners that will listen to this program.